Cameras turned off, the campaign has died, but the work we started, it never subsided. From the desert floor to the mountain height, we're shining the torch, we're bringing the light. 17 counties under one big sky, we're watching the records, we're asking them why. Oh, W4Nevada, the people's own desk, putting the truth to the ultimate test. For the school boards, the cities, the local town hall, we're showing up, brother, we're answering the call. From the receipts to the findings, we lay it all down. Accountability in every Nevada town. If the shadows are growing and you need some sun, bring it to us, now the healing's begun. Speak plainly, speak loud, let the truth be heard. We're keeping our promise, we're keeping our word. W4Nevada.com, you know where to go. Call or text that number, let the power flow. 702-381-4295. Nevada for Nevadans, we're still alive. Power back to the people, power back to the people.
Get your roller skates ready. We're skating back into this afternoon, day 11. Coyote Springs LLC versus the state of Nevada. Hey. Hey, good afternoon, Nevada. We are coming back for the afternoon session of day 11 in Coyote Springs Investment versus the state of Nevada. One of the most consequential water rights cases that we've ever covered. I think that the state has ever had covered. We are in Clark County 8th Judicial District Court, Department 13, before Honorable Judge Mark Denton. Court is scheduled back to resume at 1:15 p.m. Amelia Cargill remains on the witness stand, and Nevada is now in the recross examination. We did examination. Mark Hutchison did a little redirect. And now we are in recross examination. If you missed this morning, there was a lot to catch up on because the argument has become considerably more precise. For much of this trial, we've talked about a fairy tale. You know, it's been fairly simple conflict. Coyote Springs says it's invested an enormous amount of money into a master plan community based upon Nevada water permits, development agreements, infrastructure, and years of government interaction, only to reach a point where it could no longer get residential development moving. Nevada says that those water permits always came with conditions, monitoring requirements, senior water right protections, and the state engineer's continuing authority to respond to what the science eventually showed. This morning, Nevada started drilling directly into a critical part of a regulatory takings case. What were CSI's reasonable investment-backed expectations when this money was actually being spent? And more specifically, what did the people investing the money believe they actually had? Let's start with the banks. Nevada returned the Wells Fargo syndicated loan documents and a schedule identifying the water associated with the project. CSI has gotten an important point out of those documents. The documents distinguish between water that was currently available and water CSI hoped it might acquire in the future. The currently available category ultimately gets us back to the number that we have repeatedly heard throughout this trial. Approximately 4,140 acre-feet, when the roughly 1,000 acre-feet associated with the GID is included. That's important because nobody should walk away from this trial thinking CSI was telling its lenders that it already owned 150,000 acre-feet of developed water. It wasn't. The document separated those categories, but Nevada turned that document around this morning. The same schedule showed something much larger about Harvey Whittemore's long-term vision for Coyote Springs. It identified approximately 3,140 acre-feet directly held by CSI at that point, but also roughly 147,595 acre-feet of potential additional water within Coyote Springs Valley, along with the potential supplies from other areas including Cane Springs and Tuffy Ranch. Cargill generally agreed with Whittemore, hoped all of these available and potential sources could eventually support the entire Clark and Lincoln County Master Plan community. And remember the scale of that vision. The testimony has referenced approximately 159,600 residential units across the two counties, Clark and Lincoln. Nevada used a figure of approximately 0.71 acre-feet per residential unit for illustration and came up with something north of 112,000 acre-feet for that entire residential build-out. Cargill cautioned that the 0.71 figure is specifically associated with the Clark County methodology, which is an important qualification. But the larger point Nevada is making is pretty clear. The complete Coyote Springs vision was always expected to require far more water than the approximately 4,140 acre-feet CSI says was initially available. That doesn't answer the takings case. CSI doesn't have to prove it already possessed enough water on day one to build every house contemplated over decades. But it gives Nevada an argument that the original investors understood that Coyote Springs depended upon a continuing water acquisition strategy. Then we got into the meaning of one word: available. Jeffrey Sylvester, and/or Sylvester for the state, asked Cargill what she understood that word meant in bank documents. Her explanation was essentially water that could be committed to a map under the multi-party agreement. When pressed on whether it was legally available, she generally agreed that the approximately 4,140 acre-feet existed pursuant to those permits. But Nevada then added the other side of that equation. Those permits had monitoring requirements. And at that time, those financing documents were being negotiated. That later regional pumping and monitoring process had not fully played itself out. Cargill acknowledged the parties knew those monitoring obligations existed. So this morning gave us a distinction that I think is extremely useful for understanding this case. The banks called the water available. But the documents and testimony do not establish that that water was unconditional. Nevada attacked another part of CSI's financing argument. CSI has understandably used these enormous credit facilities to demonstrate their reliance. Sophisticated financial institutions were lending against a project tied to these water permits, the public's resource. That matters. But Cargill acknowledged today that she cannot presently identify exactly how much of the syndicated loan money was spent specifically constructing improvements at Coyote Springs. The credit facility involved other borrowers and other collateral. Draws could have covered project improvements, entitlements, overhead, and other expenses. She testified that draw requests would have been documented for the banks, but she didn't have that allocation in front of her today. She also acknowledged that later improvements after the credit facility was retired were funded by the CNO interest rather than those loan proceeds. So the financing remains substantial evidence that lenders and investors placed a real value on this project. But the credit facility standing by itself is not a dollar-for-dollar construction ledger for Coyote Springs. Nevada also established something pretty basic legally, but important for the public to understand. If a bank takes a security interest in a Nevada water permit, the bank doesn't magically get a better water right than the borrower possessed. Cargill generally agreed that the bank's interest remains subject to the terms of the underlying asset. So CSI's position is, sophisticated banks treated these permits as valuable collateral, appreciating assets. Nevada's answer is yes, but lending against a conditional asset doesn't remove the conditions attached to it. Then we moved into something I think may become extremely important, the basin-by-basin administration. Cargill has testified that CSI historically understood Nevada groundwater to be administered according to the numbered hydrographic basins. She explained what she meant. You apply for water within a basin, the point of diversion is associated within that basin. Your proof of completion and beneficial use tie back to the permit in that basin. State engineer records are organized by basin, and priority can be viewed by pulling those rights associated with the basin and looking at their priority dates. That is it. Administrative system that she says CSI understood. Nevada, however, asked a different question. Was that actually Harvey Whittemore's investment-backed expectation when the investment was being made? Cargill could not remember Whittemore ever sitting down and explicitly saying that hydrologic effects across basin boundaries did not matter. She also couldn't recall him specifically saying that USGS basin boundaries controlled regardless of physical groundwater connectivity. Her understanding came from company records, discussions with Whittemore, discussions with Water Council and other CSI personnel, state engineer records, and the way applications and permits were currently being administered at the time. That does not make her understanding meaningless. She was general counsel and was a senior executive deeply involved in this project. But Nevada is trying to make a distinction between what Cargill later understood the regulatory framework to mean and what the people actually putting their capital at risk believed at the time that they invested. Nevada reinforced that by establishing that Cargill herself has no equity ownership in CSI, no profit participation, and was an employee receiving a salary. Again, that does not invalidate her testimony, but Nevada plainly wants Honorable Judge Mark Denton focused on the expectations of Whittemore and the CNO investors when analyzing investment-backed expectations. And that's brought us back to Harvey Whittemore. Earlier in this trial, Nevada got Whittemore to generally agree with the characterization of Nevada water permit as a right to try. Cargill said hearing him use or accept that terminology surprised her. She testified during that all the years working together, Whittemore had never described those permits to her in those terms. CSI can absolutely argue that you have to read Whittemore's complete testimony and not reduce years of investment to one phrase pulled from cross-examination. But Nevada now has that phrase on the record. Cargill says that wasn't how CSI commercially treated those permits. Whittemore himself acknowledged limits associated with them when questioned in court. Then came back to what I think was probably Nevada's strongest new piece of evidence before lunch today. Nevada brought up the older testimony from Whittemore during the ruling 5918, or the Tuffy Ranch proceeding. The historical transcript discussed long-term water planning. Whittemore talked about mixing and matching different water resources depending on future demand, and then he discussed Order 1169. According to the transcript read in court this morning, Whittemore acknowledged that CSI might have to reduce pumping at Coyote Springs if the pumping affected the Maapadais or the springs. That matters, because Nevada has spent more days arguing that CSI knew the permits remained subject to monitoring regional hydrology and later regulatory consequences. Now Nevada has historical testimony from Whittemore himself contemplating the possibility that pumping could eventually be reduced if impacts were demonstrated. But there's an important CSI response. Cargill interpreted that statement addressing a situation where Coyote Springs pumping itself was actually demonstrated to be causing an impact. She also questioned whether Order 1169 itself was the legal mechanism for permanent curtailment because the proceeding originally involved pending applications. That the legal issue had not been resolved by Judge Denton here, so be careful. Whittemore's testimony is meaningful evidence that he understood pumping might be someday reduced. It doesn't mean by itself or prove that he understood Nevada could later regionalize the system in a precisely manner that CSI is now challenging. And we also got into the Moapa Valley Water District. Yesterday, Cargill brought up records showing significant continued pumping from water rights she says are junior to CSI within the broader regional priority structure. Her concern is pretty intuitive. How can junior rights continue serving the existing community, homes, businesses, and public water service, while CSI says its more senior water rights cannot support new subdivision maps? But Nevada exposed a limitation in that comparison today. Cargill could not testify that the state engineer had actually approved a new subdivision map for Moapa Valley based upon those junior rights. And she couldn't testify that the state engineer had specifically certificated for pumping new residential development. She said she didn't know. So there is evidence those junior rights continue being pumped. Based upon Cargill's testimony today, we do not yet have evidence of a directly comparable new residential subdivision being approved using those rights while CSI was denied. That distinction matters. And here's another fact that complicates the language we use around this case. CSI itself continues pumping a substantial amount of groundwater. We've talked about this. Cargill testified the CSI pumps somewhere between 1,500 to 2,000 acre-feet per year, depending on the year. How much of that is supporting the golf course? CSI's response is that an existing golf course use does not solve the problem of obtaining permanent approvals for homes and businesses. Nevada's point is different. Order 1309 did not physically stop CSI from pumping water altogether, so the dispute increasingly isn't simply, did Nevada take away every drop of CSI's water? The dispute is about the uses for which the water can lawfully support development, or whether the government's restriction on those uses cross the constitutional line. And finally, Before lunch, Nevada opened up about another significant front. Clark County versus Lincoln County. CSI spent considerable more time yesterday explaining the two county portions of Coyote Springs were treated separately for taxes, accounting, governmental services, GIDs, general improvement districts, habitat fees, and county approvals. That could become very important because the takings claim is focused on the Clark County property, while parts of the Lincoln County property have continued to present other development opportunities, including renewable energy uses. So we're getting back in here. Today, Nevada's produced CSI owns CC&Rs. The language read in court described the Coyote Springs Master Plan community as encompassing both communities and counties, More importantly, it said CSI intended the Lincoln County documents to remain consistent with the Clark County framework to provide what the document called a seamless community across county lines. Nevada loves that language for obvious reasons. It pushes against any overly simple claim that Clark and Lincoln were just two completely unrelated economic projects. Cargill immediately drew a distinction. She said the intention was largely to make the development look and function architecturally or aesthetically like one seamless community. Common architecture, design standards, community character, but she maintained that the government financial and administrative structures remain separate, and that leaves Honorable Judge Mark Denton with another potentially important question. When we talk about the property for purpose of this takings claim, are we looking at one integrated economic master plan spanning Clark and Lincoln counties, or are we looking at legally and economically distinct projects that were simply designed to appear as one community? That's not yet been decided, and it could matter enormously when we eventually reach the damages analysis. So that's what we're headed to into the afternoon. Nevada had a very productive morning. It established Whittemore's ultimate water strategy, larger than the initial 4140 or 4,140 acre feet, produced historically testimony showing Whittemore contemplating possible pumping reductions and if the impacts were demonstrated, and it produced CSI's own documents describing that Clark and Lincoln development were seamless community across county lines. But CSI still has significant answers. The lenders themselves established or distinguished available water from merely potential future acquisitions. Whittemore's historical testimony involved pumping reductions conditioned upon demonstrated impacts. And describing a master plan community as visually seamless does not automatically turn two counties, two governmental systems, two sets of financial arrangements, and potentially different parcels into one economic unit for constitutional purposes. And I think that's the cleanest way to understand where this case sits right now. For weeks, we've been asking whether CSI had water. The question Judge Denton is increasingly being given evidence is answer is much narrower. What exactly did CSI reasonably believe it possessed when it committed this money? And what regulatory limitations did investors understand came with those rights? The bank documents say the water was available. The permits carried monitoring requirements. Whittemore historically acknowledged the possibility of reductions if impacts emerged. CSI nevertheless borrowed money, entered contracts, constructed infrastructure, and pursued an enormous development around those permits. And Nevada never formally canceled those permits. Those facts now have to live together. No ruling has been made on the ultimate takings claim. No ruling has been made on the damages, and no attorney's question becomes evident simply because it was asked. We're going back into court at 1:15. It's currently 1:17, continuing recross examination of Amelia Cargill. I'm Matthew Winterhawk. This is W4Nevada Live. 17 counties, one Nevada, we the people, we the press. And thank you so much for tuning in this afternoon on our Day 11 continuing coverage in the afternoon of Coyote Springs LLC versus the state of Nevada. Thank you.
Good afternoon, please be seated. We're back on the record. The witness has retaken the stand and you may resume.
Before we begin your counsel, I have a couple of things to address. We are admitting under a stipulation. State's proposed exhibit 4019. 4019, portion of this exhibit references the confidential information that we talked about day or so ago with respect to estuary. So counsel and I are going to admit this by stipulation and then replace it with a version that has a redacted portion. Reserving the rights to come back to this court and seek removal of the redaction if appropriate.
All right,
So stipulated, Your Honor.
minute.
And then, Your Honor, counsel and I just wanted to just inquiry if, just because we're trying to schedule witnesses for next week. If there's any more updates, or we just plan on moving forward, it's based on the dates and the times you'd given us previously.
So far, that's what it's
Okay.
gonna be. We'll be reconvening on Tuesday.
Yeah, we had 2 dates that were dark.
What's that?
There were 2 dates next week that were dark, as we understand it.
Or is that the following week?
Following.
I think the following week, yeah.
Thursday might be, that's correct.
Yeah, so we're gonna start, I think Thursday, we're gonna start in the afternoon, right? Yeah, 1:30. Is that still the plan, at least for now, Your Honor?
Yes, I believe that's the case.
Okay.
Just a minute, I'm looking at my.
And then the following week, I think is when you had the 2 days dark, Tuesday and Wednesday. And does that still look like that's the case, Your Honor? Okay.
Okay, I've got next week on Tuesday all day, next week on Wednesday all day, next week on Thursday, half day. Next week on Friday. All day, it appears, right?
Yes.
Then the following week. I have an evidentiary hearing.
Okay.
That's at 9 AM. Let's see.
There's 2 days,
Well, that's, what time does it start?
9 AM on the 5th. And it goes for 2 days.
Yeah.
So that on Thursday?
And Thursday, the 27th. In the afternoon,
1:30,
10 AM.
or 10 AM
10 AM, right.
on that Thursday. Okay, great. And then Friday,
Friday is all day.
all day Friday. Okay, very well. Thank you so much, Your Honor.
Thank you, Your Honor.
So that was the only exhibit you were addressing.
Yes, Your Honor, that was the only one.
Okay, submitted,
Thank you.
subject to redactions, right?
Yes, Your Honor.
Yes, sir.
Okay.
Bernie, can I have state's proposed 3330, please?
Was 3331.
It was proffered and admitted, I believe.
No objection, Your Honor.
Okay, submitted.
And Ms. Cargill, it's a little bit difficult to read. Difficult to read, but this appears to be the CCNRs that were filed in Lincoln County. Can you read that?
Yes, I can. I would agree.
Okay. And if you would go to 010, Brendan, and if possible, place 010 next to 3331 And they take a look at those two, Ms. Cargill, and tell me if you can discern that they appear to be identical provisions in those.
That's a bit harder, but
You can make it bigger for you or smaller. Or...
no, just give me a moment. Let me see what I can do. Mr. Sylvester, based on simply looking at the first 2 words in each sentence on each page, meaning, you know what I mean, each line, they are, as best I can tell, the same. So assuming that all the other intervening words match up so that the first 2 words on the left-hand margin are the same, they appear to me to be perhaps not identical, but very, very close.
Officer State's proposed 3330.
No objection, Your Honor.
To admit, what's the date?
Much
Can't
more
read the date
difficult.
on it.
We approach that.
May we see page 1 again, please? March 31st, 2005.
Turn just to another topic and talk about the hydrologic review team. Talked about that with council on redirect. As I understand your testimony, you were indicating and testifying that on an annual basis, the HRT, the hydrologic review team, would submit these annual reports. Is that correct?
Yes, they do.
And I think, as I understand your testimony, you were indicating that at no point in time did the trigger levels under the MOU, the 2006 MOU, were ever hit. Is that what your recollection of those reports are?
That the reports have reviewed and determined there was no reason to adjust any, to move forward or to adjust any of the trigger levels.
Is that the same as saying the trigger levels were never hit? Or that they were hit and then they recover and you don't have to adjust, if you know?
That I understand your distinction, and whether or not the trigger level ever reached, according to the USGS measurements, ever actually touched any of those. No, it's not the same, but the HRT never decided that there was any reason to act on any of the, excuse me, act on any of the measured readings.
I probably didn't understand your answer. Let me try. To your knowledge, with the trigger, I understand that there was never modification or taken any action, but do you know during the pump test in 2010 through 2012, whether any of those trigger levels were actually hit?
I don't know the answer to that because no HRT report has ever suggested modifications be made. That was the only part of my testimony, was the HRT, the group assigned to reviewing those under the 2006 memorandum of agreement, never determined there was any action needed.
Okay. Randy, can I have plaintiff submitted exhibit 419, please? And this is the 2013 annual report. Can you recognize that document?
Yes, I would only say that because it then is dated July 2013, it may be for the year 2012. We'll just have to actually look at what the report is. Some years, the way they identify it on the cover sometimes is a misnomer. If that makes, do you understand what I'm saying?
Yes, I mean,
Okay.
that would, unless it's an annual July to July, then it may be from a prior year. I get it.
Yes,
But it's certainly after the pump tests were concluded, because they concluded in 2012, right?
and correct, the pump test concluded in 2012, so it would just, that's why I'm saying it would depend on what the data is that was being looked at in this report, and we could certainly discern that, Mr. Sylvester, by going through the document.
Would you go to 419-507? This appears to be a part and parcel or appendix to the 2013 annual report, and it's the test impacts and availability of water pursuant to applications pending under Order 1169 by the U.S. Fish and Wildlife Service. Have you reviewed that index or that report's attached to the 2013 annual report?
I probably looked at Fish and Wildlife's appendices a number of years ago, closer to when it was actually issued.
Brendan, can you go to 513, please? And just so that I understand, it, Fish and Wildlife is on the HRT. Is that right?
They are a signatory, yes.
To the MOU, the 2006 MOU? Okay.
Yes.
They would annually, if appropriate, submit reports in connection with those issued annual reports?
Yes, and this, I don't know who their representative was in 2013. It could have been at that time still Sue Brownmiller. I don't know if it was, but they did have a representative on the HRT.
Okay. And so we were at 513. If you look at the first full paragraph, the near uniformity, and read that portion, that paragraph into the record, and we'll do a couple of those, and then we'll move on to the next one.
The near uniformity and large areal extent of drawdown indicates a high degree of hydrologic connectivity throughout the 5 basins and suggests that carbonate pumping anywhere within these 5 basins will affect groundwater levels throughout the delineated area. We hypothesize that this portion of the carbonate rock aquifer acts as a high transmissivity, parenthetical high diffusivity, and parenthetical reservoir with fixed inflows. The potential for pumping to induce additional groundwater inflow into this portion of the carbonate rock aquifer system is very limited. As a consequence, carbonate pumping would eventually capture the only major forms of natural groundwater discharge in the area: spring stream discharge and ET in the MRSA and California Wash.
Now, this report is issued before Mr. Sino reacquires the property from Pardee.
Yes, that would be an accurate statement.
Can I go to 514, Brendan, please? And the second full paragraph, read in, please, that begins while the pumping.
While the pumping test yielded much information, there are some things that are still uncertain. The level of pumping in CSV during the test was only 1/3 of the annual volume allocated in CSV under existing water right permits, although the order required that 50% of the existing permitted rights be pumped. Therefore, the impacts of pumping half or all of the permitted allocation in this basin were not evaluated. The effectiveness of pumping reductions or curtailment was simulated with the modeling, but was not directly evaluated during the test. If the higher elevation springs stop flowing completely, it is not known how fast or how effectively the system will respond to adjustments in pumping and whether biological resources may be adversely affected in the process.
Okay, and then the last full paragraph in that page, please.
An average of 5,400 AFY of groundwater was withdrawn in CSV over the period of the test. This is only 1/3 of the 16,300 AFY of existing permitted rights to groundwater already appropriated in CSV. The pumping test provides evidence that even this reduced volume of groundwater pumping cannot be developed long-term without adverse impacts to springs, endangered fish, federal trust resources, and downstream senior water rights. Consequently, we conclude that no additional groundwater is available for appropriation to satisfy the pending water right applications that are currently being held in abeyance for this portion of the carbonate rock aquifer.
All right, so just to orient the court, the average of 5,400 acre feet of groundwater was withdrawn from CSV, and that's Basin 210 where CSI holds its rights, correct?
Yes, that is correct.
And the amount of groundwater rights that were pumped in that basin that CSI owned were the 4,140, at least from just a mathematical perspective.
Mr. Sylvester, I don't recall. We would have to go back and look. I don't know that the 5,400 was pumped by Coyote Springs or by Southern Nevada Water Authority out of its MX5 well, and that because they're just different wells. I don't recall. I thought that the majority of the water had been pumped out of the MX5 well by Southern Nevada Water Authority, but I could be mistaken on
I'm
that.
just talking about the total volume or acre feet of groundwater, because collectively CSI at that point had the 4,140, right?
And Southern Nevada Water Authority had 9,000,
Right.
yes.
And collectively, whether they pumped out of their well or you pumped out of your well or both, that collective pumping was the 5,400, correct?
Correct.
And that was seemingly having an adverse impact and could not be developed long-term without adverse impacts. Is that at least from Fish and Wildlife's perspective?
That was Fish and Wildlife's perspective as set forth in this attachment, yes.
Did that give you some concern at that point when you read that from the HRT report, if you recall?
No.
Then if we return to in that same report. I think. Go to 594, Brendan, please. I'm sorry, go back to 593, one page. And this is in the section overall report conclusions. And down at the bottom of the page, it says main findings of the report are. And if you could read the first bullet point in.
Are we still in Fish and Wildlife's report? I'm just curious at this point.
I think so, but let me just clarify it so we don't mislead you. Yes, that is my understanding of the document.
Thank you, I appreciate it.
Mhm.
So you want me to read all of this?
First bullet.
Okay, first bullet point. The effects of pumping MX5 are readily apparent in water level data from the carbonate rock aquifer over a 1,100 square mile area that is hydrologically connected and encompasses 5 hydrographic basins: Coyote Spring Valley, the Muddy River Springs area, Hidden Valley, Garnet Valley, and California Wash. There is no scientific justification for managing groundwater production from the carbonate rock aquifer separately in these 5 hydrographic basins.
And this is information that was sent both to the state engineer, right? I think you said that these reports would be sent to the state engineer.
Yes, and I also think this may be Fish and Wildlife's report under 1169,
Okay.
based on the cover page you showed me.
I was going to mention that to you. So that's what we discussed some time ago, that after the pump test was concluded, a bunch of folks had the right and opportunity, in fact, did weigh in with respect to how they interpreted the science from the pump test, correct?
Yes, and they submitted reports under order 1169A to the
Right.
state engineer.
And Fish and Wildlife, at least from what you read, indicated, at least from their perspective, those basins should be managed as one, essentially. Would you agree with that?
That is what we just read. It works. The report speaks for itself.
And recall, when we looked at 6254 and 6255, essentially the state engineer found that those basins had that hydrologic connectivity and they would be quote unquote jointly managed.
I believe that phraseology was used, but it was only related to the pending applications that were denied. Again, protecting the senior rights.
Yeah, but I mean, I don't know how you manage pending applications. I think that, I'm not trying to quarrel with you, but the language was because of the hydrologic connectivity, they were going to be jointly managed. Just recall the language.
I recall that the words jointly managed were in there. I don't recall that it was in the sentence the way you just described it. It may have been.
Can I have plaintiffs 420, please? And this is the 2014 in June. So the January, I think we agreed that the 6254 and 6255 came out in January of 2014. You remember that generally?
I remember it was 2014. It could have been January. I don't remember that. I remember 2014.
Brendan, go to 086, please. And at the top of the page, it's a derivation of responses to order 1169 pumping by the method of difference. And do you know the name Marty Mifflin and Mifflin and Associates?
Mr. Katie Johnson and Marty Mifflin. Yes, I know who they are.
And what is Mifflin and Associates?
I don't know what all Mifflin and Associates is. I know that Katie Johnson and Marty Mifflin were the Moapa Band of Paiutes, scientists and persons that participated in these sorts of matters for a long time.
Were they hydrologists, you know? Best
I
recollection?
can't recall if they were both hydrologists. They both have a variety of expertises that they espoused. I don't remember what their
Okay.
biographies were.
At 101, Brendan. And just read into the record, if you would, please, the first full sentence. It's a lengthy one.
The order 1169.
I'm sorry, Mr. Cargill. Brendan, I'm at the last full paragraph, please.
These findings indicate that full development of existing permitted groundwater rights, parenthetical, or pending applications, and parenthetical, in Coyote Spring Valley, if it is allowed, would not only result in approximately 1-to-1 reduction of muddy river flows, parenthetical, in proportion to the pumping rate, and parenthetical, but that depletion of groundwater storage in the region would proceed toward an unknown end state that must follow the observed unsustainable pseudo-steady state, parenthetical, in terms of regional drawdown rates, and parenthetical, trend that develops within less than a year. You want me to keep reading?
No, that's fine, thank
Okay.
you. And then Brendan, go to 421, please. I'm sorry, 421. This is an amended 2014. And if you look at, we'll just briefly look at 119. This is the appendix of the U.S. Fish and Wildlife Services. And if we turn it to 120. If you just read into the record that sentence in the middle of the paragraph begins specifically DOI, which I believe is Department of Interior.
Specifically, DOI 2013 concludes that had pumping from the carbonate rock aquifer in CSV continued at the rate which occurred during the 2-year pumping test, parenthetical, roughly 5,400 AFY, and parenthetical, a rate corresponding to about 1/3 of the currently permitted groundwater rights in the basin. The 2 highest elevation springs on Moapa Valley National Wildlife Refuge, parenthetical, NWR, and parenthetical, would have ceased to flow within 3 years. Moreover, spring flows, stream flows, and evapotranspiration, parenthetical, ET, and parenthetical, from ferrotypes in the Muddy River Springs area, parenthetical, MRSA, and parenthetical, and California Wash would have declined by an amount approaching the rate of pumping at SNWA's MX5 production well in CSV, parenthetical, plus an additional increment due to the continuation of other carbonate pumping in the identified 5-basin area, and parenthetical, as a new steady state was reached in the carbonate rock aquifer.
Okay, and then finally 123, please. And in the first bullet point, if you can read from whereas to the end of the sentence, and you'll be done reading the HRT reports.
Whereas this did not initiate a conservation action under the MOA, we conclude that if MX5 pumping had continued at the rate it occurred during the Order 1169 pumping test, parenthetical, or following the test for several months, and parenthetical, 5,400 to 5,500 AFY, discharge at the Warm Springs West Gauge, the location of the MOA triggers, would have dropped to 3.0 CFS or less, triggering the termination of MVWD pumping at the Arrow Canyon wells in the MRSA, and the redistribution of pumping by SNWA and CSI in Coyote Spring Valley.
When you read those reports, the 2013-14 and the amended 14, did you form the understanding that there was a significant risk associated with pumping the existing rights out of the basin 210?
No,
And that's because the triggers weren't hit?
the triggers were not hit, and if the Coyote Springs pumping precisely and only Coyote Springs pumping had been having an effect, but that wasn't what this regional pump test was about. It was about everyone in the region, but not every single pump in the region, just limited disparate wells that were pumped in the region. And it would have had to, the state engineer would have had to have then looked at doing some sort of statutory, whatever his statutory process is that you and I have from time to time called curtailment.
Well, there's two, and I want to make sure, just for this point only, there is the provision in the statutory scheme that allows regulation and restriction, and then there's a separate statutory provision, as we talked about, that really is curtailment, and that's a term apart, right?
I don't disagree.
Okay, and the curtailment would require the state engineer, again, just from your understanding, to designate the basin and then designate that basin as a critical management area, right? From your understanding.
I believe that's the correct order.
And there would be a period of time that would expire 10 years. And if an agreement hadn't been reached by and among the stakeholders, that the state engineer would just begin essentially curtailing by priority. Do you understand that generally?
Objection Foundation, asked and answered previously.
Only if you know, Ms. Cargill, because you and I had talked about the fact that there's a separate curtailment statute. I'm only asking your knowledge of the terms of that statute. If you don't have any, that's okay. I'm just trying to understand, I'm just trying to refresh your recollection. It exists to say, this is the process of curtailment. Do you understand the process of curtailment, at least statutorily?
Very generally, I don't have it word for word.
Okay, neither do I. I'm just saying, see if you agree with this general overbroad characterization that once the state engineer designates an area as a critical management area, there will be a period of 10 years that elapses before he begins to curtail by priority.
I don't remember that it was 10 years. It may be, I just don't recall if it was 10 years. I remember there was a period of time.
And do you understand that that period of time, only if you do, is designed to allow the stakeholders to come together and see if they can't reach a consensual groundwater management plan?
Among other things, as I understand it.
Okay. Brady, can I have
You want to admit that? Oh, it's already.
page 3311? I think one of the things you had indicated, Ms. Cargill, is that you had never, tell me if I'm wrong, heard the word super basin or contemplated that a super basin could have been formed by and among the various basins in the lower river flow system. Is that an accurate summation of your testimony in that regard?
I don't remember saying exactly that. I could have said something very similar to that. I don't remember saying it exactly that way.
Have you read this document before?
Yes, I have.
And do you know what it is?
It is, I think. Either you and I looked at this or Mr. Hutchison and I looked at this. I believe I've seen it in one of my days sitting here. But I've read it before that as well.
You may have seen it in the direct of Mr. Whittemore or cross of Mr. Whittemore.
I've seen it before the trial, let's put it that way.
And did you understand that that was one of the things Mr. Morris was suggesting is to create a super basin?
Objection, mischaracterized the document. Document speaks for itself.
I rephrase.
Sure. What did you understand that Mr. King or that Mr. Morris and Mr. Whittemore were discussing?
I'm sorry.
Mr. Morris and Mr. Whittemore were discussing.
Objection Foundation as to timing on this.
Would you highlight the first of all, the introduction or the to from, I should say? Looks like it's November 15th, 2004. And then the first two full paragraphs of the letter, please. Now, you've read this, and the second full paragraph says, and I'll give you a break, discussing the idea of creating a 233rd basin in Nevada namely the deep carbonate basin, Jason indicated that he had previously conceptualized this idea and was open-minded as to its application. He agreed that if there were adequate scientific proof to engage in injection in one area of the system and withdraw in another, that this would be far more desirable than a series of inter-basin pipelines near the surface. It's the first time you saw this letter in the context of this litigation?
I don't remember if that was the first time I had seen it or not. I certainly saw it in the context of this litigation.
Did you have any further inquiry with anybody with respect to the possibility of putting that Tuffy Ranch water into a 233rd basin? Or including it in a 233rd basin?
I didn't have that specific conversation. I did have a conversation with Mr. Reich.
And he told you couldn't be done?
He told me that it wasn't feasible, it wasn't realistic to inject into the carbonate in that part of Nevada and expect it to show up in Coyote Springs in any time frame that you or I could conceive.
I'm gonna end with, there's a couple of quotes from Harvey's Whittemore's trial testimony. Can I have the first one, Brendan? Some point. It's popular. Stand by. You have one job. Attention is building. Wiggle it. I thought this runner to count. Wow. These are line 21. What day is it, man? We're so good in practice. And this is the conversation on the cross-examination of Mr. Whittemore. And The reason I bring this up is you had asked to see a copy of the transcript from the trial so that you could more fully and accurately respond. And here's the question. Would you characterize a permit? You said opportunity. Would you characterize it as a right to try? Yes. Question, try and see if you can appropriate that water economically. Yes, yes, it's yes. In the most general sense, it's a right to try. Does CSI adopt Mr. Whittemore's testimony in that regard?
No,
Why not?
because a permit is not a right to try. A permit is it is the permit to put the water to beneficial use. It's more than trying. You're to put the water to beneficial use so that you can get it to be certificated.
Okay, next one, Brendan. Quicker this time. Starting
Right there.
on the answer. Oh, I'm sorry. Right, so if you have that as we go along, Brendan. Right, so the first step is I'm sorry, excuse me. First step is the water there, and is it physically there? Now, once it's there and you are starting to put this to beneficial use, and it's actually above ground, and now we are starting to see what the effects of the utilization area, then you get to curtailment and other stuff. In the first instance, we are in a situation where the permit is subject to existing rights. What that means is the permit is you are given the opportunity to prove to do the following. It's called proof of beneficial use. Question, right. Filing completion of work in the location of the wells and doing all this. No one has to say, in my mind, you are taking on a huge risk, and there is no guarantee, because the next sentence and the final water right obtained under this permit will be dependent upon the amount of water actually placed to beneficial use. To get beneficial use, it has to be there. Answer, yeah. You drill holes all over the place. You have to get appropriated water. You have to find a well. It has to be completed appropriately. And then you have to put it to beneficial use. There is no guarantee that once you are given this right, that all of a sudden the water is going to magically appear. Would you agree that there's no guarantee when you're given the permit? Or would you adopt that testimony as your own, CSI?
Question about guarantee has been repeatedly asked and answered, Your Honor.
I'm sorry, I can't hear.
I said the question about guarantee has been repeatedly asked and answered.
She wanted to review the trial transcript.
I'm sorry, what?
She wanted to review the trial transcript.
Overruled.
I would not say that that word guarantee in that sentence is in the same way you've been asking me about guarantee. So no, I would not adopt guarantee.
Okay, next, I think in the last one, please. Why is that? Because it gave us the opportunity to succeed. It's not a guarantee. Is that clearer for you with respect to whether a permit is or is not a guarantee? And if so, do you adopt this testimony?
Same objection, Your Honor, about repeated questions concerning the word guarantee.
I don't know what the question and answer here are in response to. So I can't adopt it because I don't understand the context.
Understand. Thank you for your time, sir.
No questions, Your Honor.
All right. You can stand down. Thank you.
Thank you, Judge Dutton.
Your Honor, I'm ready to call my next witness. If you'd like me to proceed. Your Honor, CSI next calls Alan Richards.
We solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes,
Please state your name and spell it correctly.
Alan Richards, excuse me, ALLANRICHARDS.
Thank you. You may be seated.
Senior. Thank you. Good afternoon, Mr. Richards.
Afternoon.
You're a fresh face on the witness stand, and thank you for being here today. Mr. Allen, Mr. Richards, you've already stated your name. And why don't you tell the court why you are here testifying today?
I'm here testifying today because I'm a expert for CSI and water rights, and I was asked to evaluate CSI's water rights and evaluate various orders and rulings filed by the state, and assess how or if those various orders and rulings may have affected CSI's ability to use its water.
Thank you,
If I
sir.
can, Your Honor, just for the record, to object on the basis of this testimony is not relevant to the pending action or the pending proceedings, and it's also barred by the doctrine of res judicata given rise or as a result of the Sullivan decision and the remand to Judge Yeager and her 2025 findings of fact and conclusions of law.
Overruled. Thank you, Your Honor. Mr. Richards, what's your current occupation?
I'm a civil engineer.
All right, and were you employed at this time and in this position?
Stetson Engineers, San Rafael, California.
All right, and what does Stetson Engineers do?
We do pretty much all things related to engineering and water rights with regard to both surface water, groundwater, stormwater, Indian water right quantifications, and a little bit of wastewater, but primarily surface water and groundwater, drinking water projects also.
How long have you been working for Stetson?
I started in February of 1993, so 33 years now.
Okay, and can you describe the nature of the work that Stetson performs in general, and then move on to Nevada specifically?
I think I just described what we do in general. Water resources, water rights, water design, construction. In Nevada, Stetson and the company has been doing work in Nevada, as far as I know, going back to the late 70s. I've personally been doing work in Nevada with Stetson my entire career.
Before we get into your work in this case, can you describe to the court your educational background and training, please?
I graduated from the University of California at Davis in December of 1992. And a training, if you mean by professional licensure, I have a PE license in Nevada, professional engineer's license in California, and also in Oklahoma. And I have a water rights surveyor certificate in Nevada.
Thank you. How long have you been a professional engineer?
I got my license in California around 1999, I think, and later I got my license in Nevada. I think that was around 2012 or 2013, and in Oklahoma, I got my professional engineer's license for maybe 5 years ago.
All right. In your professional work and in professional capacity as an engineer, what are your areas of expertise?
Well, I've been qualified as an expert in aerial photo interpretation, water rights, and surface water hydrology. I'd like to think I have higher level of skills than normal in water measurement, and I'm a pretty good design engineer. I don't know, I've never been qualified as an expert in those things, but I've done a lot of work in water measurement and water system designs for drinking water, including pipelines and tanks and water treatment facilities, pumps, etc.
Thank you. Do you consider yourself to be a hydrologist?
Yes,
All right. We'll get to that later, but you've read Order 1309?
yes.
All right. And do you recall the discussion and summary of the stakeholder experts report in Order 1309?
Can you repeat that question,
Sure.
please?
Do you recall the discussion and summary of the various stakeholders experts reports in Order 1309?
Oh, yes.
Okay. Will you offer opinions to the court about the science that was discussed in Order 1309?
Only at the court request. I wasn't planning to.
And were you asked by CSI to do that?
I was not.
Okay.
I'm sorry, Your Honor. May I take my coat off?
Sorry, what?
May I take my coat off?
Yes.
Thank you.
All right. Mr. Richards, let's move now to your work history and just experience with Stetson. What type of engineering projects have you participated in during, would you say 30 plus years with Stetson?
Most of my work, even the work that I do for municipalities, involves water rights, because not just in Nevada, but in most Western states, anybody who's using a water right is required to, or anybody who's using water, I should say, is required to have an authorized right to use that water. So most of our clients also involve, water right assistance with water right reporting, and that's true with most of the work that I've done my whole career. I've done a lot of work. I've done work for Pyramid Lake Paiute tribe in Nevada my entire career. That's largely been water resources and water rights work. I've done work in Nevada in the Walker River Basin. I've done work in Carson River Basin, done work in, done some work up in the north. I think it's hydrographic basin 195, Snake River Basin, the Pyramid Lake Basins, was hydrographic basin 81, and there's several hydrographic basins surrounding the Pyramid Lake Reservation. So I've done a lot of work evaluating water right applications that have been filed around the reservation to make determinations whether the proposed actions in those surrounding hydrographic basins might adversely impact the Pyramid Lake Paiute tribe's water resources and water rights. Let's see what else. I did some work up for the city of Ely in White Pine County. I can't remember what that hydrographic basin number is, but city of Ely was having some problems with the big Robinson mine up there. I think it was the big Robinson mine. Sorry, I tried to speak up.
Have you had any experience in transfer application, transfer application or change applications in terms of either surface or groundwater rights?
Yes, I work with a firm that has been acquiring water rights, purchasing water rights on behalf of the Pyramid Lake Paiute tribe for 25 years or so. They look for willing sellers of the water rights, and the tribe had received some settlement money years ago, which was earmarked for water right acquisition program. And so I've been working with that entity who goes out and does the water right appraisals, or actually they don't do water right appraisals, but they find somebody to appraise the value of water rights, and then look for willing sellers of those water rights. And then once the water right water rights are purchased and the ownership's conveyed, and that ownership conveyance is reported to the state of Nevada, then we file water right transfer applications. And we've been, for this particular job, we've been transferring the water rights from previous agricultural use to in-stream flows to support the fish in Truckee River and the Pyramid Lake. And I fill out the applications. Sometimes I offer some input on the water rights that are under consideration. We have to look at sort of the historical use of the water rights to, feel like they're legitimate to purchase. But I fill out the water right applications, file them with the state of Nevada, Division of Water Resources, and then I also assist with calling for that water on an annual basis. Since they're in-stream flows, we work real closely with the federal water master. We call for the water to be delivered in stream. And then when the water's available to fulfill the call 100%, then I work on preparing the proof of beneficial use forms and file those on behalf of the tribe, supported by the federal water master's records that the water was actually delivered. And apart from being involved in the water right acquisitions indirectly, that's sort of, I've done that type of work for other clients in Nevada also.
We've heard about some of the pump tests that are involved in this case. Have you been involved in actually creating, conducting pump tests and then reporting those results to state agencies?
I have been involved in designing wells for municipalities in California, not in Nevada. Stetson designed a well for the Pyramid Lake Paiute tribe, and it was drilled, but I wasn't involved in that. I've been involved in some well construction projects in California. I designed the well. I assisted getting a contractor to drill the well, and I managed construction of the well. I also, after the well was drilled, I developed the various pump tests that are required to estimate what the capacity of the well is. That's a requirement of the state of California Division of Water Resources. So I've been involved in the pump tests and designing the pump tests, preparing the report that the state requires to substantiate the amount of water that the well can produce before the municipality can update its water supply permit and use that well water for drinking water purposes.
Thank you. Have you been involved in any projects very recently in 2026 concerning water rights or water analysis?
In 2026, you're talking about things that wouldn't necessarily be in the resume that were submitted with my expert report. 2025, yeah. I've got several ongoing projects currently that involve rainfall runoff analyses, different projects for different purposes, but we're looking at rainfall runoff analyses on one project to size the stormwater facilities that would be necessary to pass the 100-year storm flow event through a person's property. And then on another project, we're looking at rainfall runoff for the purpose of evaluating water supply availability to support water right applications. I've got four, maybe five contracts with the U.S. Department of Justice. Those are all in Arizona. They involve water rights and water supply and pumping wells on the Gila River system and the Little Colorado river system, which are both adjudicated basins in Arizona.
All right, thank you. Has your work experience informed the opinions that you're going to provide as part of your testimony in this case?
Yes.
Have you, in the course of your work, evaluated and been involved with water infrastructure such as wastewater treatment facilities, groundwater treatment, installation of infrastructure related to actually putting water to beneficial use?
Yes.
And has that experience also informed your opinions in this case?
Yes.
Are you experienced with Nevada water statutes, rules, regulations, that sort of thing, the statutory and legal structure?
I'm experienced with them. Please don't ask me to cite any one specific because I don't memorize them very easily.
Okay. Have you been involved with not only filing applications, but also filing extensions of times and proof of completions and the various types of documents that we've heard a lot about in this case that's filed with the Nevada State Engineer?
Yes, I've filed proofs of beneficial use. I've filed requests for extensions of time. I've prepared and filed protests against other proposed uses of water, and that experience has required that I have a pretty good understanding of the Nevada revised statutes, because the state doesn't accept protests, that don't have some merit and some basis behind them. So we are very careful when we're making determinations whether a protest is even warranted. And we look to the Nevada revised statutes for supporting the basis of protest grounds. And I've been doing that type of thing for most of my career, as it relates to not just the Pyramid Lake Tribe, but other clients in Nevada.
Okay. As you well know, one of the parties in this case is the Nevada State Engineer's Office. And my question for you is, have you ever made appearances or testified before the Nevada State Engineer in any of their proceedings?
Yes, I have.
Can you please tell the court on how many occasions?
In my resume, I said approximately 80. I think in my deposition, I said upwards of 100. I hope that doesn't qualify me for getting impeached, but I never really calculated, the number at the end of the day. But they're all it's up in that range. I would say 80 to 100.
All right. And in those administrative hearings before the Nevada State Engineer?
Yes, sir.
Okay. Do you recall when you first testified before the Nevada State Engineer?
It was in the mid 90s.
Okay.
95 or 96, maybe.
All right. And can you give the court just some ideas about just some of the subjects you've testified about before the state engineer?
So early in my career, there were several hundred water right transfer applications were filed in the Newlands Irrigation Project, which is a U.S. Bureau of Reclamation project out in the Fallon-Burnley area. And on behalf of the client, a decision was made to file protests against something like 400 of those water right transfer applications on contending forfeiture and abandonment of the rights. And so that's where I got involved in my first experience testifying before the Nevada State Engineer's Office in administrative hearings.
All right. And during those times that you testified in those administrative hearings, were you ever qualified as an expert witness?
I was in those early, in the beginning of those Newlands project transfer cases, attorneys were attempting to qualify me as an expert in aerial photo interpretation, but I wasn't. I was denied, and so I testified as a factual witness for many years in those proceedings. Sometime in the future, at some later date, I was qualified as an expert in aerial photo interpretation. That was like maybe 7 years later. And then during an administrative hearing in 2015, I was qualified as an expert in water rights and surface water hydrology.
All right. In the testimony that you provided in those administrative proceedings before the state engineer, have you testified regarding involving potential conflicts with senior right holders? We've have some of those issues in this case, and has some discussion. Has that been something you've been witnessed and testified and addressed before the state engineer during your career?
Yes.
Okay. And you'd mentioned some of the protests that you had filed, and have you been involved with various proceedings concerning protests with water right holders?
Yes.
Let me ask you this. You'd mentioned that you or your Stetton has worked closely with water masters. Have you yourself ever served as a water master?
Stetson, the company, was hired by the San Mateo County Municipal Court in California to be the water master of a stream system that flows to the ocean south of San Francisco. And the court that's a adjudicated watershed. A decree was issued, and the San Mateo County Superior Court presides over that decree. And yes, the decree also requires that a water master be in place to administer the water rights and among other things. And Stetson was hired by the court in 2009 to fill a vacancy in that water master position. And I've been, me and a colleague, I should say, have been fulfilling water master duties since we were hired to do that work.
Has your professional work ever involved providing water engineering services for municipal water districts?
Yes.
Can you describe those, please, and which districts?
I've been involved with several municipalities in California, several on the coast, Stinson Beach County Water District, Bolinas Community Public Utility District, South Coast County Water District, North Coast County Water District. And those have involved not just water facility design, engineering, and construction, but also some water rights work. And I'm currently working on some pretty large design projects for the Osage Nation in Oklahoma. We just finished building 100-foot tall steel water tower for the nation. We put some new pumps in. We put a pipe under a river, a drinking water pipe under a river, because the existing pipe was needed to be replaced. And we're currently involved in replacing the entire sewer system in one of the Indian villages that was installed 100 years ago or more. And we got some other some other water facilities work that we're doing out there, fire hydrant replacement projects and things like that.
Now, you filed an expert report in this case. Have you filed expert reports or prepared expert reports in other matters?
Yes.
On how many occasions approximately?
3 or 4.
Okay, can you think of a few? You don't have to go through all of them, just a few of them.
So I filed, sorry, I prepared an expert report and gave a deposition most recently in 2023. That was for some litigation between a couple of vineyard growers in Napa. I did an expert report, filed an expert report on behalf of the Department of Justice, and I gave a deposition. And may I look at my resume, please?
You may.
I can't remember the years.
You brought to the stand your report. You can turn to that if you'd like.
Thank you very much. Let's see. 2023 expert report and deposition. October 2021, I prepared an expert report on behalf of the U.S. Department of Justice and a case that's still ongoing in the District Court of Arizona. I gave a deposition in that matter. I did a expert report and an expert rebuttal report and testified as an expert witness in February 2015 before the Nevada State Engineer's Office. And I didn't prepare an expert report, but way back in 2010, also on behalf of the U.S. Department of Justice, I provided a deposition and testified as an expert witness in Judge Bolton's court in Arizona.
Okay, that's a good representation. Let's just now, having talked about your education, your training, your background, let's move now to your assignment here in this case. Do you recall when you were first retained in this matter?
Yes, I was first retained in 2022 by
Okay.
Coulthard Law Services.
I'm sorry.
Coulthard Law, I might be
Okay,
pronouncing.
Coulthard Law Firm. Okay,
Yeah, thank you. 2022.
and then subsequently, had you been retained by other counsel as well?
Yes,
Who's that?
Hutchison. You're from
Hutchison and Stephan.
Hutchison and Stephan. Thank you.
All right.
Sorry.
Yep. Have you personally been engaged by either the Coulthard firm who initially retained you, or my firm, Hutchison and Stephan, and I'll even add Todd Kennedy's firm, Howard and Howard, prior to this matter?
No.
Okay. Now, you do understand that Stetson has done work for Coyote Springs and its principals. You understand that?
Yes.
We've seen reports, we've had discussions in the days before you got here about Stetson and their involvement, at least in Coyote Springs. And you know that your company's been involved in the Coyote Springs with Coyote Springs and its principals.
I do know this.
Okay. Were you personally involved in that work for Coyote Springs or its principals?
I was not.
Okay. Did you participate in the Order 1303 or the Order 1309 administrative proceedings in any capacity?
I did not.
Okay. All right, so let's talk a little bit about then just the scope of your assignment in this litigation. Just in general, what was the scope of the assignment that you were asked to take on and look at?
Well, again, in general, it was the scope for, and the scope was the same for both the contracts that I had and have with Coulthard Law and Hutchison and Stephan. The scope wasn't changed, but it was generally to review Coyote Springs water rights in basins 210 and 206, hydrographic basins 210 and 206. And with regard to the proposed place of use, the manner of use, the points of diversion, the priority dates of the water rights, change applications that move some of the water rights from one well to another, for example. And then again, evaluate various state engineers, rulings and orders that were relevant to the Coyote Springs water rights.
All right, and as part of your assignment, did you review documents in this case?
Yes,
Did you review and evaluate them as part of the process of preparing your opinions?
yes.
Right? Can you just give an overview of the type of documents? And I know that it's set forth in your report, but just give the court just an overview of the type of documents that you reviewed in preparing or formulating your opinions.
Okay, so again, I reviewed water right documents, including the maps that accompany water rights. I reviewed state engineers' orders and rulings. I reviewed relevant statutes from NRS 533 and 534, and some other statutes that are relevant. I looked at some reports published by the U.S. Geological Survey and some other water supply planning reports that were relevant to Coyote Spring water rights. Took a field trip. I took a field trip out to Coyote Springs last year, June 2025, to get familiar with the area and the facilities that were installed. What else?
Did you review any of the permits and extensions of times and related documents submitted by Coyote Springs to the state engineer?
I reviewed the permits. I did not review extensions of time that were filed for the Coyote Springs water rights, but yeah, I did review the permits.
Okay.
I didn't review. There's been some discussion about pump tests and pumping, and I didn't review anything specific with regard to how much water has been pumped from any particular well that's owned or operated by Coyote Springs. But I did review some reports that speak to underground water and pumping. But my assignment wasn't to assess the underground water.
You mentioned you reviewed some of the rulings and orders. Let me just ask you, because we've heard about them in this case. Did you review ruling 4542?
Yes,
How about order 1169?
yes,
Order 1169A?
yes,
What about ruling 6254?
yes.
Ruling 6261?
I believe so, yes,
All right. What about interim order 1303
yes,
and order 1309?
yes, of course.
Okay, great. Did you review some of the pleadings in this case?
I did.
Okay. And have you accessed the state engineer's website and reviewed some of the documents contained on that website?
I have.
All right. And were those related to your formulation of your opinions and your work in this case?
Yes.
Okay. I believe you'd maybe mentioned publications that you reviewed. Remember any of those publications?
Right off the top of my head, there was a 1971 planning report that I downloaded from Nevada Division of Water Resources website. I think we may have had some of the older USGS recon reports. They're sometimes referred to as reconnaissance reports We have some of those in our library, or they're accessible on the internet. So I looked at some of those also.
All right. Did anyone in Coulthard's office, my office, Howard and Howard, anybody else instruct you to reach a particular conclusion?
No,
Is your compensation in any way contingent upon the outcome of this case?
no,
All right, I'm sure you've submitted requests for compensation, invoices, that sort of thing.
yes.
All right. What's been just approximately the total amount of compensation you've been paid and over what period of time?
I looked that up just this morning. We've billed on the order of $150,000 since we started our work in 2022. So that's 6 years.
That's last 4 years.
$150,000 over 6 years.
Okay. All right, now,
I'm sorry, 5 years.
okay, about 5 years. Mr. Richards, upon the completion of then your work and your analysis, did you form any expert opinions?
Yes.
All right, we'll go into some detail with these one at a time, but just can you provide the court, please, with the number of opinions you have that you're going to offer before the court, and a summary of what they are, please?
General, excuse me, I'm gonna get some water.
Okay.
General, there are 4 primary opinions in my expert report. First one is that all of the water rights that the state engineer issued to CSI in the Basin 210, Coyote Springs Basin 210, and Cane Springs Basin 206. All of those water right permits were based on determinations that the state engineer made. And those determinations were that there was water available for appropriation, that the proposed use of the water would not conflict with existing rights, and the proposed use of the water would not prove detrimental to the public interest. Additionally, all of the water rights that the state engineer granted to CSI in those 2 basins came with very specific terms and provisions that required CSI to construct the works by specific dates and put the water to beneficial use by specific dates, or the water rights would be subject to cancellation. And Coyote Springs, as evidenced by one of their permits, they were able to get a certificate for one of their permits, meaning they were able to construct the works and put some water to beneficial use, and they got a certificate from the state engineer for showing that proof. But in general, they got the permits issued on those determinations that were made by the state engineer, with very state specific time deadlines to construct the works and put the water to beneficial use, and they pursued their projects.
Okay. How about your second opinion?
Second opinion is that all of those water rights that the state engineer issued to CSI and basins 210 and basins 206, Coyote Springs and Cane Springs basins, they were issued with priority dates. The basin 210 permits have a priority date of 1983. The Coyote Springs Basin permits have a priority date of 2005. And those priority dates were relative to other water right holders in those same 2 basins at the time the permits were issued.
All right. Why don't you now move to your third opinion?
Third opinion is, when this unprecedented, super basin was created, it had the effect of, combining all the water rights from individual hydrographic basins. Started off as a 5-area basin, developed over a period of 2 years from a 5-area basin to a 6-area basin and a 7-area basin, and ultimately, the unprecedented development of this super basin consolidated everybody's water rights and from those 7 individual hydrographic basins into one unit, and CSI's Coyote Springs water rights were lowered. But the relative priority of their water rights were lowered compared to some of the other water rights that became consolidated into that super basin.
All right, very well. What about your fourth opinion?
So the fourth opinion is that the ultimate result of that consolidation of water rights into a single unit and the lowering of Coyote Springs relative water rights, the result was it effectively took away Coyote Springs' rights to use its water and gave those rights to other water users in the super basin ahead of priority and ahead of CSI.
And having now stated your 4 opinions, what I'd like to do now, Mr. Richards, just turn to each of them and just discuss the bases for those opinions. All right, so let's start with the first opinion. And
Council approach, please.
all right.
I'm not sure what happened there. I'm going to assume it was some sort of confidential. Do we go to afternoon break? It's a little early for that. Not quite sure what happened there. We'll keep the camera rolling because we don't understand as to what is going on. I didn't see anything. I didn't hear anything. A little odd. We approached the bench and then 2 seconds later, camera feed cut. So a little wild.
Yeah, that's just,
Please take your seats and come to order. Department 13 is back in session.
Be seated, please. We're back on the record. What it says, retaking the stand, and you may resume.
Okay, thank you, Your Honor. Mr. Richards, let's just turn to your some of the bases for your first expert opinion concerning just the state engineer granting of permits, and you'd mentioned what your opinion was in that regard. And let's just first, and we've heard this idea before, but is Nevada a prior appropriation state?
Yes.
All right, can you please, it might sound pretty elementary, but just describe the prior appropriation doctrine, please.
Prior appropriation doctrine is one of two fundamental principles of Nevada law. Prior appropriation and beneficial use. Basically, the doctrine of prior appropriation, I think it's rooted in case law, but I can't cite what that is. But it basically is the first in time, first in right principle, whereby water right holders who acquired a water right first in time before another water right holder would be considered to have senior water rights. So it's a matter of seniority based on the date of water right acquisition. And in the case of Nevada, it's based on the date the water right application was filed with the Nevada State Engineer's Office.
Okay, we'll take a look at that coming up. How does the priority of water rights impact their value?
Objection outside the scope, Your Honor. He didn't have a valuation analysis in his report or any of his
I don't
opinions.
think he's giving an evaluation opinion. He's just talking about impacting value.
Yeah, it really goes kind of the seniority of rights that he just talked about in the prior appropriation doctrine, Your Honor. I'm not gonna solicit an opinion on value at all, counsel.
Okay.
Thank you.
Thank you. Can you just describe how does just in general the priority of water rights impact their value?
Well, in general, if your water right carries a seniority over another junior water right, the senior water right would bring a higher value.
Okay. So let's get back just to portions of your first opinion. Let's run through just a summary process of how these water permits are issued by the state engineer based on your experience, okay?
Okay.
So let's pull up, please, proposed exhibit 520. This is from your report. And you can see it's from your report, base numbered there in the lower right-hand corner. Can you please just give the judge just an overview of what you're trying to describe here by this diagram?
Well, as it's indicated in the title, it's a generalized process for obtaining water rights in Nevada. And as the footnote indicates, this flow chart was adapted from a similar, very similar flow chart that was in the Nevada Water Rights course book dated February 2015. And not every year, but pretty regularly, courses are given on Nevada water rights by various people in Nevada who have expertise in water rights. And so this chart was adapted from one of those course books. And
just before just laying foundation here for what we're going to be seeing, what is the Nevada Water Resources Association that you used in developing this chart here?
It's an association. I think it's upwards of 80 years old. It's an association of various water professionals and policymakers. And I'm a member of the Nevada Water Resource Association, a recent member. I was asked to give a presentation at one of their annual meetings a couple of years ago. But it's an association that basically provides educational information and scientific information on water and water rights, surface water, groundwater issues in Nevada to the public.
Mr. Richards, is the Nevada Water Resource Association an organization and publications that they provide resources that engineers and professionals within your industry rely on?
I do. Yeah, I rely on it. I would think others do also.
All right. So let's go ahead and walk through then, if you will, for the judge. Again, we heard a lot about obtaining water right or water permits, and just walk the judge through that process here that you set forth in your diagram.
Yeah, and again, this is a very generalized process. There's other little nuances with the actual process depending on different cases, but in general, starting at the top and towards the left, water right application is filed with the state engineer's office. It gets an initial review for completeness. In most cases, a water right application map is required to accompany the application. If there are any problems with the application or the mapping, which is not uncommon, it'll get the map or the application will get returned to the applicant for correction. And then once a map is determined, an application are determined to be complete, the application will get published in a local newspaper for 4 consecutive weeks, typically. So local advertisement in the county where the proposed point of diversion is located. And then 30 days after the last date of publication sets the end date for when protests would be accepted. So I think the protest period starts once it's in the publication process, and it ends 30 days after the last date of publication. And then, so at that time,
after protests are filed, the protest period ends, then what's the next step?
so it becomes in a state of what's the state engineer's office terms ready for action. So at that point, state engineer's office can decide whether to approve the application or deny the application. And these considerations have to assess whether protests were filed. And so there's a couple of different paths that the process can take at this point, depending on whether there's protests, depending on whether the protests are determined to have merit or not. Sometimes the state engineer will approve of an application just based on a determination that the protest didn't have merit. And sometimes field investigations are conducted by the state engineer's office to obtain additional information upon which to base their decision to approve or deny. And ultimately, the decisions to approve or deny, if there's a denial, there's a couple of if there's a denial, or the state engineer wants to consider more information before making a determination to approve or deny, hearings would be held. And then after the hearings, the decision would be made whether to approve or deny. And if the application can get sort of through that process with considerations for protests and protest grounds and the like, then and get approved, then at that point.
Let me ask you before you get there, at the ready for action point, it says that the application could be approved, and then there's a hearing rulings point where the application is approved. What determines whether or not there's a hearing held, or if you just simply have a state engineer issue the application approval after the ready for action step?
It depends on, I can't really speak for the state directly, but in general, my understanding is that sometimes the matter isn't clear, and sometimes, or maybe the state engineer makes a determination that protests or the applications deserve to have some additional information shared through a way of experts' opinions and this sort of thing. So really sort of whether the state engineer decides that it has enough information to make the decision for approving or denying, or desires to take some more information.
Okay, then once the application's approved, either after the ready for action step or the hearings and rulings, then what happens? What's the next phase?
So the next phase is the permit terms are worked up within state Nevada Division of Water Resources, and a permit is issued with
What does that mean though? Work up permit terms? What's that phrase getting at?
well, for example, almost all permits are issued with sort of standard requirements for installing water meters, measuring other provisions to ensure that the waters that's diverted, whether it's diverted from a well or from a stream, is properly measured, and those measurements are reported. The permit terms regarding the deadlines for completing the works, and the deadline for completing the works and the deadline for putting the water to beneficial use are incorporated as part of those terms.
Okay.
And that there's other standard terms, and then there's terms that are more specific depending on the case.
All right, and then the permit's issued?
Permits issued, that typically is the green light to start constructing the works that are necessary to put the water to beneficial use by the time specified in those permits. And proof of completion is typically expected to occur before proof of beneficial use. I think that makes sense. You have to have something to divert the water before you can use it, whether it's a well or a canal or whatever type of water diversion facilities is required. But show the proof of completion. In the case of a well, you would fill out the proof of completion form, provide documentation along with your proof of completion form to evidence that the well was constructed at the point of where it was intended to be constructed, and other things, if it's not a well, or go into a support a proof of completion. And then a well will typically pump to, for example, a well for municipal uses would require power source, obviously, pipeline, what the water meter that I mentioned earlier, and some place where the water was intended to be used. In the case of a municipal water right,
Okay.
it would be probably might be a drinking water treatment plant, depending on the well water quality, be a water storage tanks and pumps that would, and then the water distribution system to deliver the treated well water to the end place of use, the residential communities, for example.
Okay.
And so Well, there's a fair amount of work to get the proof of completion fulfilled. And then the proof of beneficial use process is similar. Fill out the proof of beneficial use form, provide accompanying documentation to demonstrate that the water was put to beneficial use. That would include, water meter records, photographs showing where the water was put to use, things of that nature that would demonstrate that the water that was permitted was used within the constraints of the permit terms. In other words, you need to file a proof of beneficial use if you want your certificated water right to represent the quantity of water that was granted by the permit. Then you would want to show proof that you beneficially used the full amount of water that you were permitted. And so otherwise, you could get a certificate of beneficial use for something less than what the permit actually allowed. But that's not something that that's typically something that is reserved for situations where there is no real way to put the full amount of the permit to beneficial use.
Okay, in this case, we've heard Coyote Springs has 1,500 acre feet of certified water. What does that mean and why is that significant?
It means they pumped water, means they complied with the deadlines to complete the works that were required to get the water from the well to the place of use. Means they filed proof satisfactory to the state that they used a specific amount of water, and it's a showing of due diligence, and basically, and it's a completion of that due diligence process is what it is. Because if you need more time to show that you completed the works, or you need more time to put the water to beneficial use, you have to file applications and requests for extension of time. And those requests for extension of time require evidence that even though you weren't able to put the full amount of your water to beneficial use, you were diligently pursuing the process to get that done.
Okay, we'll get to extensions of time here in just a minute. Is this process that you just described here, is this something that you've seen during the course of your career of 33 years as an engineer and working and focusing in water rights processes?
Yes, almost my entire career.
And are these steps set forth statutorily? Are they state engineer requirements? Do you know?
Or statutory requirements.
Okay.
Excuse me.
And when we talk about project development process after the permits are issued, is that when the actual permittee can begin constructing and building or developing infrastructure to be able to actually ultimately put the water to beneficial use?
Yes. I mean, once the permit is issued, it basically starts the clock, so to speak. It starts the clock. It starts the period during which the permittee has to put that water to use, or it becomes subject to cancellation.
All right, thank you. Your Honor, I'd offer Exhibit 520 as a summary of the statutory and regulatory requirements for obtaining water rights in Nevada?
I think it's hearsay, Your Honor.
I have it in already, it's.
520? Is that it?
That would
Yeah, I
surprise
believe
me.
it came in on the 12th. Yeah, it came in on the 12th.
Okay, thank you, Your Honor.
All right.
You said just put an appraisal in there too?
Thank you. Exhibit 520 is in?
Yes.
Okay, thank you.
More circumspect.
Thank you, ma'am. All right, now. You mentioned in your first opinion, what the state engineer had to do in order to issue the permit. And we've heard about these requirements numerous times. We've seen them in various rulings. And before the permit could be issued in this process, the state engineer has to undertake statutory review and evaluation.
Yes,
Okay, and what does the state engineer have to determine before issuing the permit?
there are several criteria, and some of them are case specific. But in general, all of them require that three things: that a determination that there is water available to be appropriated, that the proposed use of the water will not conflict with existing rights, and the proposed use of water will not prove detrimental to the public interest.
All right. You had mentioned that there are specific timeframes that the permittee or the water holder has got to put the water to beneficial use. Generally, how long is that? How long do they have to actually put the water to beneficial use in general?
I think in general, it's 5 years to construct the works and 10 years to put the water to beneficial use.
All right. And if there's a need for additional time, is that when you file an extension of time?
Yes.
Okay. And we've heard a lot in this trial about beneficial use requirement. And just from your perspective and your experience in the water arena in Nevada and elsewhere, but particularly Nevada, what do you understand the beneficial use requirement of the state engineer and the statutory requirement to be?
Beneficial use requirement is sometimes we've heard of it as the use it or lose it provision of law, but it's a proof of beneficial use, and proof of beneficial use is defined in the statutes, or I should say beneficial use is defined in the statutes, and it's generally the amount of water required to put the water to use for its intended purpose.
All right. And how does the permittee or the permit holder know what the intended, what the purpose is for that water? Got to put the beneficial use for a specific purpose. How is that determined and dictated?
Well, typically it's specified in the water right application by the applicant, and then it's also specified in the permit once the permit is issued.
What responsibilities is placed on the permittee under the beneficial use requirement? What's, I guess, requirements are imposed on the permit holder?
An application which becomes a permit, it typically the permit will specify where the point of diversion is located, what the proposed manner of use is, where the proposed use is located. It'll often specify a diversion rate limitation and a diversion quantity limitation. And so the permittee is required to stay, within the confines of those specified criteria.
Thank you. We've heard reference to water permits as a right to try in this case. What's your opinion about that characterization?
I've never heard of that before today.
Okay. Have you seen it in any of the statutes
No,
or industry recognized publications?
none.
How about used in any of the state engineer proceedings that you've been involved in over the last 33 years?
None that I've been involved in and none that I've read.
Okay. Now, you talked about the process of actually providing proof of beneficial use. And what type of information, what type of evidence does the permittee have to provide the state engineer usually in general to obtain proof of beneficial use?
Well, again, almost always some form of record showing water metering or measurement information, both in terms of rates of diversion and quantities of diversion, and documentation such as aerial photographs in certain cases, or field photographs, or other records that that are persuasive and demonstrate where and how much water was used under the permit.
Thank you. We've heard a lot about these requests for extensions of time, and just to lay a little bit of foundation, what does the permit holder have to do to demonstrate to the state engineer in order to obtain an extension?
The main requirement is to provide evidence sufficient to the state engineer that the permittee is diligently moving forward with its project, even though it may not have been able to complete it. That's the main requirement, is due diligence, working towards completion.
And we've seen lots of forms that have got to be filled out with the requisite information the state engineer requires for those extensions of times. Have you seen those?
I have.
Okay. And it includes things like, and we've seen it many times, expenditures and what specifically is being done to pursue due diligence in putting your water to beneficial use.
What specifically is being done and how much additional time may be required and why.
Okay. And is the state engineer required to grant an extension of time when an application is submitted?
No.
What are the options that the state engineer has typically once he receives an application for an extension of time?
Approve, deny, request additional information. I think those are probably the three primary options: approve, deny, or request additional information to base a decision on.
What about when state engineer receives an application for a permit? Does the state engineer have to issue the permit?
No.
What are the options he has?
Approve, deny, and request additional information. And I'm not sure if there's even a time frame required for the state to approve a permit. So I could be wrong on that, but in general, I think another option would just be to hold it in abeyance for whatever reason.
Did you see an example of that, like in Order 1169?
That is a good example, yes. Order 69 specifically was holding pending applications and in abeyance, and it also specified that no new applications would be considered during that 2-year pump test period.
Okay. I'm gonna turn now just to an example, one that is very famous in this case. Of a permit that had been an application for a permit, and this is exhibit 150. If you pull that up for us, we've seen this many times. This is the famous permit number 46777. Which we've talked about many times in this case. And let's just want to focus your attention on just a couple of things, and I think you already have seen these points in this trial, but coming from you as an expert, just want to touch base with you on them as well. You had mentioned, sorry to get that up there. All right. Let's just pull up the first, maybe half of that, Hunter. And we've seen this so many times. I'm not going to spend a lot of time going through this, but we see just in general, the date of the filing. That's an important date, as you'd mentioned, right?
Yes,
December 31st, 1983. That becomes the priority date if the permit is actually granted.
yes,
Okay. And then we see, we see who the or where the source of the proposed water is going to come from. Number one, right? We see how it's to be used, industrial. At least initially, that's what was this permit was to be used for, right?
yes,
All right. And we've seen later in this trial already, well, that would be changed to domestic or municipal. And then let's go down to the second half. And then you talk about these different dates, and we'll see these different dates when they'll begin to start the actual work of construction down there, number 7. And then there's a description of actually the proposed work that's going to be undertaken in order to put the water to beneficial use. All that stuff you testified to. It's just an example of that. And we've seen this many times. All right, thank you. Well, let's see. Let me just go back up to number 2. Excuse me, I'm sorry, just move to page 2. And highlight that first top part there. Good. State engineer then makes a note. You talked about protests before. Go down to the protest section there, right there at the very top now, Hunter. Well, it wasn't top. There you go. Right. And so there's identifications of protests, and if the protests are overruled, the state engineer notes that. And then he also notes his approval. Right?
yes.
All right. And we've seen that many times. So what I'd like to focus your attention on is just a little bit of the language here, a couple places of the language. We've seen this, these phrases before, and I'd just like to get your comments on them as an expert in your field. The state engineer approves it, and then he says in the very first sentence, this permit is issued subject to existing rights. Can you comment on that language, whether you've seen it before and what it means?
I have seen it before. It's a standard term that's put in most, if not all, permits.
Okay, and what meaning do you attach to it in your professional capacity?
This this statement basically goes to priority, and without saying it, what it's saying is what its meaning is that the water, the right to use water under this permit with a priority date of 1983 in this case is subject to excuse me, subject to other existing rights and their priority dates.
All right. And does this phrase to you have a connection to the prior appropriation doctrine that you described previously?
Yes,
How so?
that's what the prior appropriation doctrine is about.
Right.
First in time, first in right. This particular permit, like I said, has a priority date of 1983, and the use of water under this right, for example, in times of shortages would be subject to other rights that might have earlier priority dates or might be senior.
All right. Let's look at some other language that we've seen before, and that is that the last sentence of this paragraph. The state retains the right to regulate the use of water herein granted at any and all times. You've seen that many times referenced in this case. Same question to you as a professional and with the experience of 33 years in the field. Have you seen that language before? And if so, what does it mean to you?
Yes, I have seen it before. It's a standard term that's put in most, if not all, permits. What it means to me is that the permittee is required to use this water right within the constraints of the permit terms and conditions, including how much water can be used, where the water can be diverted, and the state is indicating that they control the right to regulate that use. It's not just a permit that is granted without any constraints.
Thank you. Your Honor, I'm getting ready to move to a different topic. I know you've got are we gonna break at 3:35? Would you like me to continue or should we break?
Well, we can go ahead and break now.
Okay,
Okay, let's adjourn now and reconvene Tuesday at 9:01.
sounds great. Thank you, Your Honor.
Enjoy your weekend, ladies.
Well, I guess that's where today's coverage is going to have to end. Well, I didn't know we had a hard stop at what time we're at? 3:35, so we're 3:31. We'll get that day's wrap-up report out, and we'll be back here tomorrow. Or excuse me, we'll be back here Tuesday. Let me know if you have questions, comments, concerns. This is the continuing coverage and ongoing coverage of Coyote Springs LLC versus the state of Nevada. My name's Matthew Winterhawk, and you're watching W4Nevada Live. Please do make sure to share this out. We're having serious issues with visibility out there. We have quite a following, but for some reason nobody sees us. That's odd. Isn't it Facebook, Kick, Twitch, Instagram, YouTube, X? We're on all of it. 7 different platforms live at one time, posting daily and posting updates. Over 20,000 followers collectively. Yet we're getting impressions less than 20. That's not by mistake, ladies and gentlemen, so please do us a favor, share it out. And thank you once again, everybody that tuned in today. We do appreciate each and every one of you from all 17. Carson, Clark, Churchill, Douglas, Elko, Esmeralda, Eureka, Humboldt, Lander, Lincoln, Lyon, Mineral, Nye, Pershing, Story, Washoe, and White Pine counties. All 17 here and accounted for. Not just 2 in a sports book, right, Clark and Washoe? I mean, we love you. Not as much as you love yourself, but we do love you. We got to remember the other 15, you know. And, as I always say when we end this show, and you should be remembering, as we're not just Vegas, ladies and gentlemen.
We're not just Vegas.
See you Tuesday.
Read the whole map. Read it. Lights don't run the state. No, they don't. That's a small cap. Small cap. We're not just Vegas. Look around. Past the neon haze. Past it. 17 counties. All of them. Different lives, same place. Same soil. Same soil. They think Nevada starting in on the strip. That's like judging a book off the cover it get. Vegas loud, yeah, but that's just a slice. Plenty state left once you drive past the lights. This town's where a handshake still means something. where folks know the land and the seasons are blunting, where work don't trend and patience is learned, where votes still matter cause people return. We don't all gamble, we don't all party. Some folks wake early, boots dusty coffee. Some places quiet, some places spread. Some rows long conversations with your head. The state breathe wide, not stacked in a frame. Don't shrink us down to a postcard name. We're not just Vegas, no way, no way. That service talk, surface, real Nevada, out here, outside the walk, outside. This land where the sky feel heavy or blue, where the silence louder than the news. Places built slow, no rush to impress, where people still show up, not just express. Some counties keep food on shelves you don't see. Some keep water managed responsibly. Some keep the lights on, roads still paved. Some keep the history from getting erased. Not every voice come with billboards and sound. Some carry weight just by sticking around. We don't move fast, cause we plan ahead. We don't burn bridges just to feel sad. Nevada ain't one tempo, one look, one lane. It's contrast stitched into the same terrain. We're not just Vegas, past the glare, past it. The state move quiet, steady, everywhere, all around. If you move here, welcome, just learn the pace. Respect the ground, don't rush the place. We don't copy cities that couldn't hold. We're not just Vegas, yeah, no. Read the whole map, read it. Lights don't run the state, no they don't. That's a small cap, no. We're not just Vegas, look around. The neon haze, past it, 17 counties, all of them, different lives, same place, same soil. They think Nevada starting and on the strip. That's like judging a book off the cover it get. Vegas loud, yeah, but that's just a slice. Plenty state left once you drive past the lights. There's towns where a handshake still means something, where folks know the land and the seasons are blunting, where work don't trend and patience is learned, where votes still matter cause people return. We don't all gamble, we don't all party. Some folks wake early, boost dusty coffee. Some places quiet, some places spread. Some rows long conversations with your head. The state breathe wide, not stacked in a frame. Don't shrink us down to a postcard name. We're not just Vegas, no way. That surface talk, surface. Real Nevada, out here, outside the walk, outside. This land where the sky feel heavier blue, where the silence louder than the news. Places built slow, no rush to impress, where people still show up, not just express. Some counties keep food on shelves you don't see. Some keep water managed responsibly. Some keep the lights on, roads still paved. Some keep the history from getting erased. Not every voice come with billboards and sound. Some carry weight just by sticking around. We don't move fast, cause we plan ahead. We don't burn bridges just to feel sad. Nevada ain't one tempo, one look, one lane. It's contrast stitched into the same terrain. We're not just Vegas, past the glare, past it. Stay move quiet, steady, everywhere, all around. If you move here, welcome, just learn the pace. Respect the ground, don't rush the place. We don't copy cities that couldn't hold. We watch, we learn, then we choose what to mold. This state don't need to be louder to matter. Pressure built here long before chatter. Votes cast local, still shift the frame. Power spread wide, that's the game. We don't ask permission to be all